Hello there. My name is Allison Wright, and I'm a partner and shareholder at the law firm of Pappas Wright located in Rock Island, Illinois. I'm pleased to be here today providing a podcast to you on behalf of the Illinois Community College Trustees Association. This podcast is being recorded at Blackhawk College campuses. For this podcast, we're going to be talking about the Illinois Tort Immunity Act, which provides some of the greatest legal defenses available to public community colleges throughout the state. So what we're going to talk about is what that statute is, who it applies to, what some of the immunities and rules are, including that truncated statute of limitations. And then, of course, we'll circle back to those trustee takeaways so that you can implement in your day-to-day governance. Now we're going to be talking about the Illinois Local Governmental and Governmental Employees Tort Immunity Act. And that's a somewhat lengthy statutory name, so today we will simply be referring to it as the Tort Immunity Act. And as trustees, we all know that your service to your boards and your colleges is not your full-time job. You are public officials, not employees of the college, but that does not mean that you cannot get sued or have claims brought against you. It also does not mean that your conduct isn't important. In fact, your actions could greatly impact the college you govern and its liability. And today we're going to talk about some of the strongest legal defenses available to public community colleges, and those arise under the Illinois Tort Immunity Act. So as a brief overview, we're going to cover 5 main topics for the Tort Immunity Act. First and foremost, what is it and who does it apply to? Second, we're going to look at the special statute of limitations that applies to tort claims filed against your college. This shortened or truncated statute of limitations requires someone to sue within a fairly short period of time, and for risk analysis as a board, it's always helpful to be aware of when those claims exist and when they expire. Next, we're going to talk about discretionary decisions and the absolute immunity afforded for those discretionary decisions under Section 2201 of the Tort Immunity Act. And after that, we will talk about misrepresentations and what immunity applies to statements or communications from you, your board, or your college. You will learn there are different rules that apply depending on if the statement is oral or written and whether it was negligent or intentional. And lastly, as always, we will circle back and hit the main trustee takeaways from today's podcast. So let's dive into all of that now. The Illinois Tort Immunity Act was passed into law in 1965. And while it is most important to focus on what the law says today and how it impacts us today, understanding government immunity requires a quick trip down memory lane. So let's jump back to the 1950s. During that time, government entities were protected from liability, meaning they were immune from being sued under the doctrine of sovereign immunity. Illinois courts and judges had a hard time agreeing on the exact standard to be applied, and there were different rules on immunity then applied to cities and municipalities as compared to schools or school districts. The Illinois Supreme Court took a firm stand against these diverging rules in 1960 when it abolished the concept of sovereign immunity, meaning it said they could now be sued for tort claims. A number of laws rolled out in response to the Supreme Court's 1960 ruling in Molitor, and in 1964, one of those laws was struck down. However, our Supreme Court gave a clue as to what the legislature could do next. In its 1964 opinion of Harvey v. Clyde Park District, the court said a law could be passed if it was based on functions rather than being based on the type of public body involved. So heeding that suggestion, the following year, in 1965, the Tort Immunity Act was born into our Illinois body of law. So how does it impact you, your board, and your college? Well, it impacts you in a big way because it defines how you, your board, and your college can get sued for tort claims. So let's first take a look at who and what the Tort Immunity Act applies to. As public institutions, it applies to public community colleges in Illinois. And who within the community college district does it provide immunity for? The definition applies to employees, and that might sound concerning since none of you are employees of the college you serve, as we previously noted in this podcast. And of course, you want immunity whenever you can get it. But fear not, because the Tort Immunity Act has a very broad definition of employee. And as you can see on this slide, it applies to all present and former employees, agents, officers, members of a board, commission, or committee, volunteers, or servants. So we've clarified now that the Tort Immunity Act does apply to you, your board, and your college, but let's look at exactly how it impacts you. And we'll start with the first rule, which actually has to do with the statute of limitations. Now, the statute of limitations, of course, is the period of time an individual has to file a claim. If a claim is not filed within that time period, the claim is barred. Now, the Tort Immunity Act provides significant protection to you, your boards, and your colleges simply by having an unusually short statute of limitations for tort claims. And that time period is just 1 year from the date of the alleged injury, which in the big scheme of things is a fairly short period of time. In fact, it is among the shortest statute of limitations available. And in my practice, what we have seen time and time again is that a lot of plaintiffs don't know about it, and a lot of plaintiffs' lawyers don't know about it. So what happens is they file lawsuits against you, your board, or your college for something that happened well over a year ago, and then your defense counsel files a motion to dismiss and gets the case thrown out because the Tort Immunity Act says any claim has to be filed within a year. And I will tell you, in many of our cases, I have had the opposing side tell me personally, and even tell the judge in open court, they had no idea this short statute of limitations was even in the law. They just assume some of the general 2 and 3 year statute of limitations apply. And in every case where this has come up, do you know what the judge has told them? Too bad. So long story short, one of the top protections afforded to you, your board, and your college comes by way of the short, truncated statute of limitations from the Tort Immunity Act. And whenever facing litigation, you and your legal counsel should always, always, always evaluate if the one-year rule applies. Now, we just talked about what the Tort Immunity Act is, who it applies to, and when tort claims must be filed against you, your board, and your college. Next, we're going to talk about what specific immunities are available under the Tort Immunity Act and when those will and will not apply. Now, assuming that a claim is timely filed within the 1 year statute of limitations, we're going to look at some of the key legal defenses that provide immunity to you and your college under the Tort Immunity Act. And we'll start with the granddaddy of them all, the immunity found in Section 2201. Section 2201 provides absolute immunity for discretionary acts. It reads as follows: except as otherwise provided by statute, a public employee serving in a position involving the determination of policy or the exercise of discretion is not liable for an injury resulting from his act or omission in determining policy when acting in the exercise of such discretion, even though abused. Now, that is quite wordy as usual, but within Section 2201, we find an immunity that applies to you, your board, and your college, even if the conduct at issue was willful and wanton, meaning it was deliberate. Now, with any statutory definition, we of course break them down into the key elements to help demonstrate when it applies and when it does not. So turning to Section 2201, which provides absolute immunity, meaning it applies to both negligent and intentional conduct for discretionary decisions, we're going to break that definition down. What we know is that a public employee or a trustee will be granted Section 2201 immunity when these 4 things are met. The employee serves in a position involving the determination of policy or the exercise of discretion, and the claim is based on an alleged injury arising out of his or her act or omission, and the act or omission involved determining policy, and the act or omission involved the exercise of discretion. Now, there are many cases involving Section 2201. As further information on these definitions, I've provided examples on this slide. Community college positions that include the determination of policy or exercise of discretion include things like the board members or trustees, which would be you guys, college presidents, college administrators, and even faculty, instructors, and other staff. Now, what kind of decision involves the exercise of discretion? The best way to distinguish them is the same way our judges do. There are discretionary acts, and then there are ministerial acts. Discretionary acts, as our Illinois courts have confirmed, are those that are unique to a particular position. The term is extensive. It applies to any act which involves independent thought or decision-making arising out of a particular public employee's position. So as you can imagine, that means there are a lot of them. I have included some examples from our Illinois cases confirming the types of positions and the types of decisions that are involved. And as you can see, everyone from trustees to other college staff can make discretionary decisions. And you see on this slide, the types of decisions or conduct recognized as discretionary is very, very broad. Now, by contrast, ministerial acts are those that are performed on a given state of facts in a prescribed manner under a mandate of legal authority and without any reference to discretion. So Section 2201, widely known within this area of law for providing the greatest protection and immunity to you, your board, and your college, will bar tort claims when they are based on decisions that involve independent thought or decision-making for particular positions. And we have seen and had great success utilizing this immunity in litigation given its broad reach. But not every immunity is so sweeping in its application under the Tort Immunity Act. In fact, the next two we're going to talk about have to do with statements made by community colleges and what, if any, immunity might apply. And most often, claims involving statements or written comments have to do with some sort of a representation or misrepresentation, rather. And the Tort Immunity Act has different rules for different types of statements. You'll see there's a distinction drawn between oral and written misrepresentations, and there's a difference between negligent statements and intentional statements. So what I have on this slide here is a summary of the rules that come out of various sections of the Tort Immunity Act. So here they are. The Tort Immunity Act provides absolute immunity to you, your board, and your college for any injury arising out of an oral misrepresentation made, regardless of whether it was negligent or intentional. So if a claim is based on something said orally and not in writing, that claim will be barred. Now, the Tort Immunity Act also provides immunity for statements made in the scope of employment, either orally or in writing, when the statement involves a negligent misrepresentation or a negligent statement about providing information. So if a claim alleges the board negligently stated something or negligently provided information, that claim is barred, and it should be dismissed away early in your litigation. And this applies to both written and oral statements. So to recap, any claim for negligence against you, your board, or your college based on a statement made is barred by the Tort Immunity Act. And we have successfully used this defense in many cases, and there's very little gray area with it. So it's a great immunity and defense to use. So many would ask at this point, when does liability potentially attach to tort claims with misrepresentations? And that's with written, intentional statements or misrepresentations. We know you are immune from liability for oral misrepresentations, regardless of willful or wanton conduct. And we know that you are immune from liability for negligent misrepresentations, whether it's written or oral. But the Tort Immunity Act does not, I'll repeat, does not provide immunity to you, your board, or your college for intentional misrepresentations that are made in writing. And given the very nature of the way we communicate now, with everything finding its way into an email or text message or social media post, it is very important for trustees to understand that the Tort Immunity Act does not, again, I'll repeat, does not afford protection for intentional misrepresentations made in writing. So you want to be conscious of what you say and how you say it. These cases lose immunity potentially if you say it in ink, even if you say it with a wink. Now, we've touched on a few of the main provisions of the Illinois Tort Immunity Act. So for your trustee takeaways, I'm going to recap our highlights from this podcast with 10 key takeaways. First and foremost, the Tort Immunity Act applies to Illinois public community colleges and to you as trustees. It applies to a variety of tort claims. It does not apply to contract claims. So the defense of immunity will not be available for you, your board, or your college for breach of contract claims. Tort immunity is not absolute, as we've discussed under the Tort Immunity Act. Discretionary immunity under Section 2201 only applies if the act involves both the making of policy and the exercise of discretion. Also under Section 2201, we'll remember ministerial acts are not covered by discretionary immunity. Now, with regard to misrepresentations, the next rules, individuals cannot bring suit for negligent oral or written statements. Individuals also cannot bring suits for negligent or willful and wanton oral statements, but they can bring suit for willful and wanton written misrepresentations. So remember, what you say and do as a trustee could result in liability for you, your board, or your college. So how does that translate into best practices? Well, here are 5 trustee tips incorporating these principles into your everyday governance. First, when evaluating risk and legal exposure, consider if the Tort Immunity Act applies and review whether that 1-year statute of limitations may provide a very strong early defense. Number 2, understand that the act of one trustee could initiate liability, so collaborate on issues, especially those where there is significant risk or even disagreement among your board, to to ensure how you act is in the best interest of your board and your college as a whole. Number 3, be careful what you say and how you say it. Understand that your words are not automatically immune from liability. Understand the difference between negligent and intentional conduct, and choose your points, positions, and representations wisely. And of course, always be careful with electronic communications. It is easy for texts, emails, or Facebook posts to get taken out of context or lost in translation. So remember that not all written representations are covered by immunity. Always remember and consider the Open Meetings Act as well to ensure communications don't exceed the threshold amount of trustees and trigger a meeting or notice requirement under OMA. And lastly, remember that the Tort Immunity Act provides significant protections to you, your board, and your college, but never forget it is limited in many ways and it is not absolute.